5 seconds to go. Start. CCTV footages also reflected that Constable Amit Dey slept the deceased in the duty officer's room. The DIG in his report has opined that the arrest of Qazi Nashiruddin was due to sudden provocation and scuffle with Constable Amit Dey, and the summons of arrest under Section 42 of CRPC was very flimsy without any basis, as he was known to the police authorities, being involved in 3 other FIRs at the Dhania Khali police station. As per the third opinion by the superior officer, the local police violated the provisions of Section 49 of CRPC, Section 50 CRPC, Section 50A CRPC, and Section 51 of CRPC. Fourth opinion in the report refers to the police officers, in furtherance of their common intention, arrested the victim to further harass him, and negligence on their part led to the death in custody. The other opinion of the superior officer, which is relevant, is that the police officials of Dhania Khali police station did try to suppress the fact of injury in the inquest report, which was revealed during the inquest conducted by the magistrate as well as in the post mortem. According to the superior officer, the death was because of negligence on the part of the police authorities. However, according to him, Constable had beaten the victim deceased, and SI Ashim Mondal prepared incorrect record in the form of inquest report, and as such they have committed offences under the sections for which the investigating officer has charged. Learned advocate appearing for the CBI relied upon Jacob Matthew versus State of Punjab and Haryana, reported in 2005-6 SCC1, to establish her contention that the offence herein falls within the ambit of Section 304A of the Indian Penal Code. The present judgment relied upon do set out principles and the guidelines in case of medical negligence. As such, factual background of the case relied upon has hardly any relevance in respect of the subject matter which is addressed in the present revisional application. Learned advocate for the CBI also relied upon the judgment wherein the subject matter of rash and negligent act was considered in the background of driving a vehicle. The part of the doctor to attend the patient that may be a cause of civil negligence and not a culpable negligence falling under the provision of Section 304A of the Indian Penal Code. After relying upon the aforesaid precedents, learned advocate for the CBI emphasized that the proceedings before the learned magistrate should be allowed to continue under the relevant provisions for which charge was framed by the learned magistrate, and there is no scope for interference with the order dated 2nd August 2017. Learned senior advocate appearing for the petitioner, on the other hand, submitted that there are oral evidence reflecting torture being inflicted upon the deceased. Such oral evidence is to the extent that there were assault and torture being inflicted upon the deceased, to hold that the deceased, who was illegally arrested, assaulted, and tortured, which resulted in his custodial death, as a rash and negligent act would be simply denying justice to the de facto complainant who, from the inception, had to fight for justice for approaching this court on umpteen occasions. Stop.